Today we're with David Shapiro. David Shapiro is a criminal defense attorney located in San Diego, California. We've received a number of questions online, and he's agreed. These are actually specifically drug-related questions, and he's agreed to answer these for the people. With that said, if you're someone who's finding this video and has some questions for him directly, he's actually agreed to answer the questions in the YouTube video. So if you have a question related to drug-related offense or about a drug-related offense, just simply post it to the questions below in the video. And obviously, if you have any, if you've been charged directly or have some direct questions, you can just give them a call. With that said, David, I want to go ahead and get started, and we will send you over the first question that was posted here. I've been charged with possession for sale of methamphetamine. Is it possible to claim this for personal use only?
Well, it's certainly possible. How effective that will be will depend on a lot of things. There's a big difference, obviously, between possession for sale and simple possession. There was a big difference, obviously, factually, and since November of last year in 2014, there's a big difference in consequences. Prior to November and the passage of Proposition 47, simple possession of an offense like methamphetamine could be a felony or a misdemeanor, carrying a maximum of 3 years in prison or in local jail. Health and Safety Code 11378, which is possession for sale of methamphetamine, carries the same amount of time, but is priorable in that in the event you're convicted of a possession for sale and then you get another charge of possession for sale in the future, your exposure doubles because you could get up to 3 more years based on the prior possession for sale. So now we're in a situation post Prop 47 where it's either a felony where you're facing up to 3 years, a non-reducible felony, a straight felony, or it's a misdemeanor for possession versus possession for sale. So some things that matter as it relates to whether you can argue effectively that this was possession, not necessarily possession for sale. First thing is obviously the amount. If it's a gram or 2, 3 grams, 4 grams might be pushing it, but if it's personal use, you could argue that. If it's kilos or if it's 10, 20, 30 grams, it's a little bit more difficult to say that was for simple possession. Something like a pay and owe sheet, cell phones, and the case of Riley versus California, the Supreme Court case, which arose out of San Diego actually, which was a couple of months ago, put the kibosh on the police going through your cell phone in most instances without a warrant or without showing an exigency. A lot of times clients of mine would be stopped and the police, in an attempt to build up the difference between simple possession and possession for sale, would go through my client's cell phone. And if there's nothing there, great. If there's text messages talking about drug sales and drug possession and moving drugs and payments and all that type of stuff, not so great. Baggies, how the drugs are packaged, whether or not there's scales, multiple scales, whether or not weapons were involved. All those things are factored in. In fact, I resolved a case, possession for sale case earlier today, where it was over the line as it relates to the amount, and there were some indicia or indications of possession for sales. They were able to work out a really good deal where the client was looking at up to 6 years in prison if convicted, and now when they come back for sentencing in a couple of months, they're looking at no worse than 90 days jail with the possibility of alternatives. So, remember, you don't necessarily need to prove anything. It's up to the government, in this case, on state cases, the San Diego District Attorney's Office, if the case arises out of San Diego, to prove that not only did you possess the drug, that you possess it for purposes of sale. They need to meet their burden. We don't need to do anything. We certainly will, though.
All right. Well, 6 years to 90 days is pretty impressive. But so the next question we had here was, my boyfriend was caught selling Molly, MDMA. He had 15 pills on him. He's still in jail. Is he going to prison for a long time for just having those 15 pills?
Well, first thing, 15 pills, not a lot, which is good. To answer the next question, I'm assuming he's in jail because he's unable to make bail. Assuming he does not have a criminal record with that amount, 15 pills is really not a lot. Can he go to prison? Legally speaking, no, if you're referring to prison as state prison in California, California Department of Corrections and Rehabilitation Center or facility. Okay, why not? Because in 2011, the law changed where certain felonies you cannot go to state prison, assuming you don't have a prior record that says you can. So in this instance, he would be only confined in county jail. Now, a lot of people would prefer to go to prison if they're getting a lengthy sentence. But legally speaking, he cannot step foot in state prison for just selling 15 pills of MDMA, okay, assuming he doesn't have a prior record. Would he go to prison without a prior record in San Diego County? Probably not, but jail would definitely be in play if he gets even felony probation. Felony probation could be 0 days to 365 days in jail. So, 15 pills, I think, would go more to the first question which was posed. I'm not sure if it's the same person. I don't think it was. But the first question talked about simple possession versus possession for sale. There could be an argument there that it was simple possession. However, if I remember the question, it talked about sales, and then the issue is who was he selling the drugs to? Was it an undercover? Was it an informant? Was it, someone on the street? Who knows? There's a lot of variable factors that go into it. But to answer your question, it definitely depends. Not having a criminal history would certainly help his cause. Having a good attorney would certainly help his cause. Not self-incriminating himself any further after he was taken into custody will certainly help his cause.
Okay, makes sense. And ironically, you literally tapped into the next question that we have here, which was, is it possible to have a drug sale charge totally dismissed if you were selling to an undercover?
Yeah, I mean, anytime a drug sales charge is always possible to get it dismissed, no matter what charge, irrespective of whether you're selling to a common user on the street, whether you're selling to an undercover or not. A lot of times, particularly here in San Diego, we've seen a lot of drug sales cases. I've represented a lot of people on drug sales cases where it originated even online, like on a Craigslist or a Backpage.com type of deal. And the person posts something online or responds to an ad. Next thing you know, they're meeting in some parking lot somewhere, and the person showing up to purchase the drugs is not necessarily a user, is an undercover officer. But just because it's an undercover officer doesn't necessarily mean it's a sunk case. There's a lot of things that they tend to screw up from time to time, which could definitely help and could definitely be used to possibly suppress or keep out certain key pieces of evidence, and could certainly be used in your favor or in your friend or loved one's favor in the event they find themselves in this position. The problem that I see a lot of times with undercover is there's more of a history, there's more of a backdrop to it than just observing a hand-to-hand sale on the street, or if it's a rat or a snitch or an informant or something like that. If law enforcement is doing their job properly, they're saving these communications. They're usually trying to induce or get the person to say the key words that indicate that, hey, that was their plan from the get-go. There's text messages that are saved a lot easier than if it's two people as opposed to one person that's undercover. So it's possible. It's not the greatest case in the world on its face, but there's certain things that tend to get screwed up from law enforcement's end that can certainly be exploited from time to time.
Okay. And here was the last one that was posted for you. My son was caught with 90 pills of Adderall. His prescription, he has a prescription, but I do not believe they are from the doctor. So these pills are not from the doctor, I guess. Is it possible to say that those were the ones on his prescription, but he hasn't used them? Meaning, she's basically asking if he can say that those pills were actually my prescription and I just had more of those.
It's a complex and convoluted question there, but yeah, I mean, you could definitely use the fact that if X number of pills are lawfully prescribed to someone, and they have X number more than what they're lawfully prescribed, it's still a crime. But then the issue is if you have, I think, what was it, 50 pills? Was that the question?
90 pills.
90 pills, and you're prescribed 60. Then the issue is, should it be treated as you have 30 pills, or should it be treated as you have 90 pills? What I mean by that is if you're lawfully allowed to have 60, then that should be debited or credited, so to speak, off the total amount. Okay, that's a big problem too, especially as it relates to something like Adderall, or particularly painkillers here in San Diego and nationwide, where people are taking or abusing their prescription drugs and double dipping, so to speak, as it relates to two doctors, going to two doctors and getting prescribed the same medication so they can double up and self-medicate. It's definitely something you could argue. Having a valid prescription for any controlled substance, even if you're abusing it or using more than the amount allotted or prescribed, is certainly a mitigant, if not a defense. What I mean by that is, It could be a defense if you have 60 pills and you're prescribed 60 pills. It could be a defense to possession for sale if you have 90 pills and you're prescribed 60 pills. But it's certainly a mitigant if you have a valid prescription, not necessarily a defense to the crime, but something that could be portrayed to the prosecutor's office and to the court if necessary. Again, all part of that distinguishing you from everybody else. This is not someone who's just rolling around with 90 pills of Adderall. This is someone who's prescribed. Maybe there's a history. Maybe there's previous diagnoses or medical conditions that require the Adderall to begin with. Not necessarily a defense, but something that's going to distinguish you from everybody else. And in this case, get your son the best possible outcome, as good if not better than anybody else charged with that health and safety code section for unlawful possession of this controlled substance. So, certainly possible. Everything's possible, but you need to do, and he needs to do, a lot of things that could help mitigate his case.
Okay. All right. Well, Dave, thanks for your time. Thanks for answering the questions. If you were one of the people watching the video and had some additional questions for Dave, just post them on the bottom of YouTube, and he'll get back to you with his answers. Thanks again, Dave.
I definitely will. My pleasure. Take care.